Place set for the show cause hearing in this matter for contempt for failure to provide parenting time. I'll let you know we're going to take some brief, testimony from the parties. I'll let everybody know that everybody will have an opportunity to speak. So don't interrupt anyone else or don't interrupt the court. You'll have an opportunity to speak your piece. So on the we do have the show cause hearing. We also have the motion for change of custody and parenting time. I'm going to address the motion first because that will be the easiest matter to get resolved. So, Mr. Kelly, you can proceed with your motion.
Your Honor, essentially, that motion is based primarily on the issues we've had ongoing in relation to compliance with the court order and my client getting parenting time. It's directly and impacts the child custody factors, and I'll name the ones that are impacted due to this withholding occurrence. The love, affection, and emotional ties existing between the parties. It looks at the emotional bond. Him being prevented from seeing his kids is preventing him to continue that emotional bond and nurture that emotional bond, which he had prior to this latest withholding that has started back on December 27th. Factor B, the capacity and disposition of the parties involved to give the child love and affection that focuses on the ability to, again, parent to foster an emotional bond in the future. He's having a hard enough time in the present, again, because she's not keeping in compliance with the court order, and he's not able to see these girls to be able to have a solid relationship and foster that relationship. The length of time they've lived in a stable, satisfactory environment, I'd submit to the court. Defendant's home is not stable, considering the allegations she's made that have been investigated by CPS twice, police twice, and both been denied. Nothing's come of it, which leads me also to the moral fitness of the parties involved, which ties into the same factor. But we have to keep in mind, Your Honor, at the beginning of this case, he was charged with domestic violence in relation to her essentially going after him to get keys to his truck so she could get some pot and smoke it. As he's being arrested, she's telling him, "I want you to come home." He, of course, gets him on bond. He can't have any contact. Once the bond conditions get lifted, she's contacting him through text and saying, "Hey, let's meet you and the girls get together and we can go to the zoo, or we can go to a park."
Okay, Mr. Kelly, how does this relate to your motion?
It's related to, Your Honor, again, the moral fitness involved, as well as the stable, satisfactory environment, in that she's accusing him of sex with girls. But before all this, she's wanting him to come home. She's wanting a relationship with him. She's wanting her family essentially reunified. Those two things don't jive together, Your Honor. And I would think that essentially it's a fabrication, which would go again to the moral fitness and also to the mental and physical health of the parties, Your Honor. You're making these allegations, these terrible allegations, but on the other hand, you're still wanting the same guy who's supposedly doing this stuff to come into your house. Finally, Your Honor, the unwillingness and ability to...
All right, folks, buckle up, because today we are diving headfirst into one of the messiest custody battles you'll ever witness. On one side, we've got Dad, trying desperately to exercise his court-ordered parenting time. On the other side, we've got Mom, aka our self-proclaimed Courtroom Karen, who seems to believe court orders are more like suggestions. And to make things even spicier, she's been accused of inventing wild stories to keep Dad away from his kids. But here's the kicker. When the judge gives her a chance to defend herself, instead of keeping calm, she takes the nuclear route, talking back, ignoring warnings, and setting herself up for a courtroom takedown you do not want to miss. Will her excuses hold water? Or is this judge about to deliver some instant justice? Let's break it all down.
Facilitate and encourage a relationship. Again, this is the fourth motion we're here this morning on, Your Honor, for him to see his girls. She doesn't follow your court orders. She withholds them for no valid reason. And she's clearly shown she's not going to facilitate a relationship between him and his kids. I think that's more than enough that gets us over the threshold of a change in circumstance or proper cause, because these things are having a significant impact on these girls' lives in terms of having a relationship with their mother. So we would request, as part of our relief, that you set this matter for an evidentiary hearing. We're also requesting during the interim that my client get temporary parenting time starting today, and that he continue to have them until the evidentiary hearing. That mom's parenting time be supervised at her expense, because she's clearly shown an unwillingness to follow your rulings or to comply with your court orders. I think if you don't do that, she's gonna take these kids and run, and we're gonna be in a bigger mess than we are today.
Okay, thank you. Ms. Couch, if you wish to speak to the motion.
I had some statements, but it's just what I had submitted to the court.
Okay, go ahead, tell me, and then
Okay, would you like me to stand?
whatever you wish. If it's more comfortable sitting, go ahead, but speak up a little. So we can-
Okay, I said that his first statement was true, but the second statement that he said was false. I said I previously tried to change parenting time because of the videos the plaintiff had been watching. It was reported to Penfield's police department because plaintiff was previously residing in Penfield.
Notice how Dad's lawyer isn't just talking about visitation. He's strategically hammering away at every custody factor. Stability, emotional ties, moral fitness, cooperation. It's like he's lining up dominoes so the judge can clearly see that Mom isn't just bending rules. She's steamrolling right over them. And let's not ignore the irony here. This is the fourth motion for Dad just to see his kids. 4. At some point you have to ask, if someone is willing to defy a judge's order this many times, what makes you think they'll ever stop without serious consequences?
Errors were made by the plaintiff's attorney. The sixth statement is also false. There is supposed to be a pending CPS case, and I was never told otherwise. CPS and I have spoken on numerous occasions and decided that the best course of action was therapy, which the minor children are attending at Summit Point. I do have proof of all of that as well. 7, that's also false. I was never told that they were declining to investigate the police. Number 8, it's false. In early 2024, my mom threatened to call CPS on me because of the children's odd behavior, requesting that I get them checked by the doctor. I had the doctor examine them at their 2-year checkup, and almost 2 months later, the plaintiff was arrested for domestic violence. I originally withheld the kids because of the plaintiff's sexual preference for diapers and enemas, knowing that the plaintiff was not mentally stable enough for unsupervised visitation. The 9th statement is true. The 11th statement is false. The 12th, I'm unsure of the plaintiff's employment.
And here we go. Classic Karen move. When cornered, bring in CPS, police reports, therapy, and just about every acronym in the book. But here's the problem. All those investigations? Denied. Closed. Nothing came of them. Yet she keeps repeating them as if saying it louder makes it true. It's like a broken record of excuses designed to muddy the waters. The judge isn't blind here. He sees the pattern. And you can practically hear him thinking, if all these agencies don't buy your story, why should I? What do you think? Is she really concerned for her kids, or just...
Kelly, what the court will do in this matter is the court has read the pleadings. Obviously, you're well aware of the file in this case. The court does believe that the plaintiff has met the VARCA threshold of proper cause, change of circumstances sufficient for an evidentiary hearing. So the court will schedule an evidentiary hearing in this matter. Mr. Kelly, you can proceed with your show cause hearing. Do you wish to take testimony from your client? Okay, Mr. Connolly, if you step forward, we'll have you sworn in and then we'll take some testimony. And I say brief testimony, I don't need to get into.
Sure, we'll keep it straight and to the point here. Have you been getting your parenting time?
No,
Why not?
because she is refusing to let me see them.
Have you attempted to get your children from this couch?
Yes,
Have you called the police for their assistance?
yes.
What happened when the police got involved?
That she slammed the door in their face, denies them, and just tells them no.
Have you filed motions with the court to get parenting time?
Yes,
Has the court awarded you make up parenting time?
yes,
Most recently,
This is wild. After spinning a laundry list of accusations, Mom drops the ultimate bomb. She wants the court to order no contact between Dad and the kids. Think about that. A father who's been begging to see his children, who's filed motion after motion, and she wants him erased completely. This isn't about compromise or safety anymore. This is about control. And here's the kicker. The judge is about to remind her who actually calls the shots in this court.
did the court award you parenting time in January of this year?
Yes,
Did you attempt to go pick the children up for that makeup parenting time?
yes.
What happened?
She refused to give them to me again.
Do you approximately know how many days you have missed so far as simply your overnights for parenting time?
20.
Would you like the court to grant you some makeup parenting time this morning?
Yes.
No further questions, Your Honor.
Okay. Ms. Couch, do you have any questions for the plaintiff? No?
Straightforward, brutal. Dad gets on the stand and confirms exactly what we all suspected. She flat out refuses to hand over the kids, even when police are involved. Slammed doors, ignored calls, court orders treated like scrap paper. Notice how clean his testimony is compared to hers. No dramatic extras, no conspiracy theories, just facts. And in court, facts speak way louder than fiction. If you're the judge listening to this, which side?
Has there been occasions when you have gone with him to go get the girls and anything happened in regards to him actually getting the girls?
Prior to December 27th, yes. After December 27th, no, she refused.
Let's talk about prior to December 27th. What would happen?
We would go, then we were meeting at Riverside Park and we would wait for her to show up. When she'd show up, she'd let the girls out and they would come running up to Zach and we would take them.
Okay. Did something change after December 27th?
She just started refusing to give the give the girls. His first visit that he was supposed to was I'm not sure, but I got a text from Athena on New Year's Day saying
Okay.
that she was going to refuse to give the girls. Either she would not be home, he would text her and she would not respond, or if she was there, we'd knock on the door, she'd open the door and then just say no and slam the door in our face. So we would go back to the truck and call the police for the police to come out and assist.
And the police came out and
This testimony hits different. It's not just Dad being denied. Even Grandma confirms it. And you know courts take grandparents seriously, especially when they corroborate the pattern. Think about what Grandma described. Kids running happily to Dad before December, then suddenly cut off cold turkey after Mom decided she didn't feel like following orders. That emotional whiplash for the kids? Devastating. This is the kind of evidence that shows the court it's not about safety. It's about one parent trying to control the